All rise. The justices of the court. Hear ye, hear ye, hear ye. All persons having business before this, the appellate division of the Supreme Court, let them draw near, give attendance, and they shall be heard. Be seated and come to order.
Good morning, everyone, and welcome to the Appellate Division Second Department. On behalf of Presiding Justice Hector de La Salle and my colleagues, thank you for joining us today. Let me introduce to you the panel of justices who will hear your appeals. To my right, we have Justice Valerie Brathwaite Nelson. She's from Queens County. To my left, we have Justice Joseph Maltese. He's from Richmond County. And to my far right, we have Justice Linda Christopher from Rockland County, and I am Justice Fran Connolly from Westchester County. At this time, we ask that you Thank you. You may proceed.
Good morning, Your Honors. My name is Jacques Munro, and I am the pro se appellant in this matter. I come before you to protest a grave injustice that has been perpetrated against me since my return to the U.S. in August of 2018. I have been battling the corruption, oppression, and counterfeit documents perpetrated by the New York City Child Support Enforcement, prohibiting me from saving my only son's life from the most dangerous country in the world for Americans, as stated by the U.S. State Department. In light of my findings, who knows how many other victims they have destroyed? 2 separate law enforcement agencies have declared documents submitted on November 18, 2020, to this court by former lead counsel Elizabeth Rita Hayes as counterfeit court documents. The District Attorney's Office of Queens and the Federal Bureau of Investigation have both examined these documents and has asserted, without a doubt, that the documents submitted to this court, referred by counsel Jesse Townsend in his December 27th briefs, Exhibits 1 and 2, are in fact fraudulent. In 2019, I applied for a position at the Federal Bureau of Investigation. Based on my experience and several tests and interviews by a panel of several federal agents, I was accepted into the FBI as a grade 8, basically a lieutenant. I was later informed by the FBI that because of a past due amount of $428,000 from child support enforcement on my credit report, which raised a red flag, I was told that the FBI does not accept candidates that have a valid child support order, and I could be disqualified from employment at the FBI. Upon further review, and according to the FBI court database, I am clear of any open judgments anywhere in the U.S. I was advised to investigate further and that they would hold my position for up to 6 months. I immediately began my investigations. I offered to this court my employment contract with the Federal Bureau of Investigations and my credit report, should the courts want to see it. After several letters of correspondence with the New York City Child Support Enforcement to correct the accounting, I was informed of a money judgment by Child Support Enforcement in the amount of $111,745, record of trial, page 305, which is the foundation of this entire case, and the $470,000 is just interest and illegal child support modifications. Record of trial 277, 278. On January 13th, 2020, I visited the family court's records room to retrieve a certified copy of the money judgment supposedly issued on November 9th, 2004. The records room clerk pulled my case file and, after careful research, informed me no money judgment exists. Needing undeniable proof to present to the child support enforcement, the clerk provided me with the only document pertaining to my child support case within my file. This document consisted of all the court's activities on my support case from the beginning, November 9th, 2004, to the end, June 2019. A certified copy of the order, signed and sealed by the very same support magistrate, David A. Cushblum, who signed the findings of the fact. And today, I offer this court the original certified copy of the findings of the fact in the record of trial, page 101. And by offering the originals to this court, that this document is without a doubt authentic and beyond contestation. Upon my first attempt in submitting my briefs to this court, 2 reply briefs by respondents were submitted to this court. On November 18th, 2020, the first was by counsel Jesse Townsend of Corporation Counsel. The second was by Elizabeth Rita Hayes, Department of Social Services. In Ms. Hayes' briefs, it contained 3 exhibits, 2 of which were not in the record of trial, in which she used COVID-19 as an excuse as their absence. Please bear in mind, the very first time I've seen and viewed these fraudulent documents was when Ms. Hayes submitted her briefs to this court. In family court, the money judgment does not exist. In the Supreme Court, a typed form of a money judgment was submitted, but not signed by any judge, support magistrate, or court of the clerk. Record of trial, page 97, 98. Nevertheless, Counsel Townsend supported the fraudulent documents that former lead counsel Elizabeth Rita Hayes submitted in both his briefs, including making several references to Ms. Hayes' November 18, 2020 fraudulent court documents, beginning Exhibits 1 and 2 in his December 27 briefs. I immediately emailed Exhibits 1 and 2 to the FBI personnel for review and examination. After submitting my documents, I was asked to come in person and bring in 2 certified copies of the order that was signed by the same support magistrate, along with a certified copy of the findings of the fact. Originals only. After obtaining and submitting these documents to the FBI, I was told that the documents were submitted to forensic investigation to verify my claim that the judgments were counterfeit. After 2 weeks of review, I was informed by the FBI that the judgment and the supporting documents were in fact forgeries. I was then informed that I would not be disqualified as a candidate from the FBI and that they would hold my position for up to 6 months, awaiting this court's decision to close the file on this issue. I was then informed to bring the court's decision regardless of the outcome. After my findings at the FBI, I went to the District Attorney's Office of Queens to file a complaint. I was directed to speak to the head investigator, Sergeant Richard Lewis. Sergeant Lewis inspected Ms. Haynes' Exhibits 1 and 2, the counterfeit documents, with the original findings of the fact. Once reviewed and inspected, he declared the documents to be completely fraudulent. Sergeant Lewis compared the signatures of the counterfeit documents that were actually filed, findings of the fact, and concluded they are completely different from the authentic signatures. Sergeant Lewis then made it clear to me that the money judgment is not on the findings of the fact, making Exhibits 2 statement, the judgment stand, as an altered court document. Sergeant Lewis stated to me that this have been a repeated occurrence for fraudulent court documents that they have implemented using digitalized security codes over the judge's and support magistrate's signature. These codes, 1, authenticate the signature, and 2, certify that the signature is for that specific document. Sergeant Lewis then proceeded to show me with a magnifying lens the numbers over the support magistrate's signature and explained to me how to read them. The first 8 numbers in Exhibit 2 are 201600309, identifies as the dates of the document, which must match the other 2 dates of the upper right-hand corner and the lower left-hand corner of the document. The digitalized codes state March 9th, while the date of the document states March 7th, a 2-day difference. I offer this court the originals so they can examine, and I brought with me, just in case you don't have, magnifying lenses. Upon the findings, Sergeant Lewis proceeded to open an arrest file. We were just about finished with the whole ordeal, and he had all the information that he needed and asked me one final question. Which courthouse did Ms. Hayes turn in the counterfeit documents to? I informed him the Appellate Court, 2nd Division in Brooklyn. He immediately stops me, and he refers me to the Brooklyn DA's office because his jurisdiction is in Queens, and the crime occurred in Brooklyn. He then stated that he will attempt to find someone in the Brooklyn DA's office to prosecute in criminal court. And in the meantime, I should file a complaint at the Brooklyn DA's office, which I did. Complaint in hand, and I offer it to the courts. Your Honors, I have been battling this unprecedented case of fraud that is worth $500,000 to the Child Support Agency. My son's safety and well-being, which is the main purpose of child support enforcement, is worthless to them because he is not in their system, which leaves my son in constant danger and having been kidnapped for a second time. Opposing counsel states in his briefs that OCS were justified in denying my passport, which is the basis on counterfeit falsified documents. Another excuse to rationalize blackmail and extortion. Your Honors, New York City Child Support Enforcement and Human Resource Administration are attempting to validate child endangerment with a pile of money. Since when did currency outweigh a child's life? Counsel Townsend has made a gross error stating on the record in his December 27th briefs, page 4, claiming of a money judgment, record of trial, page 80. The truth is of the matter, it is nothing more than a grievous, erroneous accounting statement based upon fraudulent document as named on the top of the page and prepared by Child Support Enforcement. Counsel is attempting to obfuscate the main issues and assassinate my character. But if Your Honors will direct your attention to the bottom of the page, record of trial, page 80, in the remarks section, you will note that it clearly states, as a note by Child Support Enforcement, that I, Jacques Munro, walked in with a certified copy of the Supreme Court order issued by the Honorable Joseph P. Dorser in May 2003 to delete $100 child care expense per week from the beginning, 1999. And Child Support Enforcement said they will not comply with the order, proving direct civil contempt in their own admission in writing. Referring to falsified court documents and disobeying a direct court order is certainly not the way to assassinate my character. It only proves New York City Child Support Enforcement flagrant disregard for the courts and its laws. This entire case was based on fraudulent court documents and orchestrated by the New York City Child Support Enforcement in direct violation of the U.S. Constitution, in which we all swore to protect. Article 6, Paragraph 2 of the U.S. Constitution is commonly referred to as the Supremacy Clause. It establishes that the federal Constitution and federal law generally takes precedence over state laws and even state constitutions. For 22 years, I have felt the needs of child support enforcement on my neck and the injustice inflicted upon me and my family. I have been stripped of everything that I have worked for. I have not seen my son for 7 years and have been struggling for 4 since I found him. And Child Support Enforcement has denied me my passport to pick up my son, who has lived without his parents since he was 8 years old because of their denial of my passport. He has been kidnapped for a second time. The District Attorney of Brooklyn is awaiting a call from this court. Your Honors, I await from justice to take place and the relief I seek. I once believed that Corporation Counsel and Department of Social Services was a decent institution, representing various New York City agencies and children, until I was on the receiving end of every kind, of every degree of deception. Former lead counsel has been operating behind the scenes so McKeevely, it has rarely been my experience to meet such a machination group. Furthermore, I request from this court that former lead counsel Elizabeth Rita Hayes, if in an audience, be taken into custody to be remanded to the District Attorney's Office of Brooklyn to face criminal charges for filing a false and forged court document to this court is a felony and is punishable by up to 3 years in prison and substantial court fines. It has been appallingly clear that Corporation Counsel and Department of Social Services integrity and humanity is absent in this matter. I pray the day comes when both are restored to a normal sense of decency, because family is where life begins. Thank you.
Thank you very much. You may be seated. You may proceed.
Thank you, Your Honor. Good morning, Your Honors. Jesse Townsend for the respondent. This court should affirm Supreme Court, which correctly denied the petitioner's two arguments that were properly before it, which are the request for the reinstatement of his passport and the removal of the $54,800 in child care expenses from the much larger total amount of his child support arrears. The remaining arguments made in this court as well as below were either unpreserved, time-barred, or...
Counsel, the argument here is there's a mathematical error, that there was a partial reduction of support many years ago, and the compounding and calculations going forward with interest resulted in the mathematical error here. What do you say to that?
Two responses, Your Honor, to Justice Maltese, your question. The first is that although there was a 2003 order from Supreme Court that abated that child care line item, there was a subsequent 2004 family court order, and the two courts had concurrent jurisdiction over support in the divorce case. And that 2004 order specifically stated that all elements of the earlier support order, that's 2001, continue. That thus picks up that child support line item and carries it forward. And that's that leads to the $54,000, which again is a much larger part of the much larger total arrears. That is just one line item, Your Honor. So, of course, even if that were entirely stricken, there would still be a very large child support arrear. And that said, my second response is petitioner was out of time to bring in Article 78 to challenge the agency's decision to not remove that $54,000.
So, counsel, you were required to submit evidence that the petitioner was notified of its determination dated September 17th, 2019. Did you do that?
The petition itself alleges that, Your Honor,
but you have to submit proof.
The letter is in the record, Your Honor. That September 17th letter. Did
you prove its mailing?
I don't believe the envelope is in the record. However, the petition itself alleges that that was received, and that's why that is the final determination with regard to that particular issue, the $54,000, and that's why petitioner was out of time as he filed his petition in March as opposed to.
And who requested that his passport be seized? Is that the agency?
It was the agency following the federal and state process in the early 2000s. Once a child support arrear is above $2,000, there's a process by which communication goes ultimately to the State Department, and thus the passport is placed on a non-
But this gentleman is trying to retrieve his son from Haiti, and he claims he's been stopped from doing so by an agency seeking child support payments. Is that correct?
That's right, Your Honor, in that he applied for an emergency reinstatement.
And you opposed it?
The HRA determined that he didn't meet those qualifications. It was a very strict restrictions on this when the emergency reinstatement is permissible. and that's set by state guidance. The city's agency is following state guidance, and the agency determined he did not qualify.
So retrieving a kidnapped child doesn't qualify.
Because the description of the is so strict, it's something like a medical emergency. And there's no allegation that this child is facing medical emergency or is...
In Haiti.
He was facing a threat to his life.
I don't believe that's supported in the record, Justice Braithwaite Nelson. With regard to that he was threatened with his life. That certainly the allegation is that he was kidnapped and that...
Well, there was a reasonable, there's an argument that reflects that there's a reasonable belief that this young man could have been in danger. His life could have been in danger.
That was not borne out by the record that the HRA considered and applied its judgment on. Under the Article 78 proceeding, this court owes deference to the HRA's determination. If I can address, Justice Christopher, your comment about the location of the child, that he is in Haiti. He was born in Haiti. The petitioner was voluntarily in Haiti. This is not a case of a child who was stranded in a country that was not his own.
Oh, but things have certainly changed quite a bit in Haiti, have they not? In the last few years?
There's a lot of tragic news out of Haiti. That is certainly true.
We've had kidnapped Americans, citizens, etc.
You're certainly right, Justice Christopher, that the news out of Haiti is tragic and there are risks. It's just that I would just push back on the perception that this is a child, again, in a country that's not his own, or that he was in some place unexpected, or
he's there without parents.
He's in Haiti. His father is here in the United States. Evidently, the mother is identified, according to the petitioner, in Europe. And so, in the meantime, he is variously either with a grandmother or...
So that is not viewed as an emergency situation?
Not under the definitions... Right. Sorry to cut you off, Justice Braithwaite Nelson. Not under the definitions as described by HRA's superior agency, the state agency. It's not described as a medical emergency. There's no evidence of a medical emergency in that sense.
So I wanted to ask you about the claims of fraud that are being made here, and how do you respond to those?
Sure, Your Honor. This case was being litigated in the midst of the most restrictive aspect of the COVID pandemic. When responding to the Article 78 petition, HRA's trial counsel accessed the version of the 2004 money judgment that she was able to. Their family court especially was in a very restrictive situation, as I know Your Honors know. And so the unsigned version was what was available at the time to be accessed and to be included in the opposition, or the motion to dismiss the Article 78. When the petitioner brought a motion in this court, asking this court to vacate that money judgment, which was not his actual Article 78's request, but he asked it in this court on a motion. At that point, because that was later in the year, we had more time and we were able to access the signed and certified version, which is what we included in our opposition to that motion. They're the same document. They're just, we were able to access the certified version later in the year.
Is the money that you're seeking for the benefit of the child that's in Haiti?
No, Your Honor.
Or other children?
Well, and that child is now an adult, and so the real beneficiary is the ex-spouse who supported that child for basically her entire childhood. And that's the ultimate beneficiary behind this, and that's also, that person's an absent party. That would be the person who would benefit from actually recovering a measure of this amount, this total amount.
So it's not the same child that's in Haiti?
It is not the same child as in Haiti. It's
Another child.
Tiffany, right?
Correct, who is now an adult, but again, her mother would have been responsible for her upkeep for her entire childhood, essentially, and that's what this child support represents.
So you're claiming that there's no portion of this judgment. Well, first of all, is there a judgment?
Yes, Your Honor. There's both the judgment as well as the continuing obligations after the judgment.
Mm-hmm. And what's the amount of the judgment?
The amount of the judgment is something like $111,000. Then there's interest on top of that. Separate from that, however, are both the core child support obligations as well as the child care expenses going from 2004 to 2015.
So in 2004, how old was Tiffany?
She was born in the late 90s, so she would have been 10 or less.
So how long do you think she needed childcare?
Well, that I do not know, Your Honor.
Excuse me?
That I do not know, Your Honor.
Right. So did you charge him with, so was he being charged a specific amount, monthly amount for childcare when?
Until 2015, Your Honor. So let me just clarify that slightly.
Until the child was, what, 18 years old?
Correct. So in 2019, Mr. Munro moved for a vacatur in family court. Family court, before the same support magistrate, engaged a retroactive termination, so you say, of the child support,
In
capping it
2004,
to 2015, Your Honor.
until the child was 18.
Correct, Your Honor. And so from 2004 to 2015, both the basic support and the child care expenses would continue, 04 to 2015. And for the child care expenses from 04 to 2015, that's that $54,800. The base expense is a separate line item, and that also continued.
So the $111,000, does that include the $54,000 in childcare?
No, Your Honor, those are
It's a separate,
Right, because everything until
which adds up to the over 400,000.
altogether, the judgment, the interest, then everything between 04 and 2015, which was not encapsulated in that prior judgment, altogether is over 400,000.
And have you attempted to collect on this judgment?
As far as I know, no. As far as I know, the only step taken is this passport step, which was taken many years ago because the petitioner fell behind in his child support many, many years ago. And all that's required to be included in the passport denial program is to be $2,000 behind. So regardless of the $54,000, regardless of the judgment of $111,000, Justice Christopher, there's no way in which petitioner is not behind in the child support to an amount to be included in the passport denial program.
So has there ever been an attempt to do some sort of workout with this gentleman, that he pay X amount a month and then you'll release the passport?
Actually, I believe petitioner represents in his appellant's brief that there was this discussion of indirect confession of a judgment of some fraction of the total. I personally don't have any information about that. I wasn't involved in such discussions, but based on that, it sounds like there could have been.
All right.
What's the agency's position with reference to these allegations that these are fraudulent judgments that have been filed with the court?
That's just not true.
Just not true.
That's just not true. I would note, Your Honor, that the family court proceedings were presided over by a magistrate support judge in Queens County, Justice Kirschblom. That was the same justice to which petitioner sought to have his arrears vacated in 2019. That was the justice, as I was saying to Justice Christopher, that was the justice who capped the arrears at the 2015 when the child became an adult. Otherwise, upheld the entire balance.
Okay, thank you very much, counsel.
Thank you, Your Honor.
Both have a good day. Next case is going to be number 9, Grabowski against Orange County.